My name's Lewis O'Brien. I've created this 5-minute guide series to property development contracts to help those who want to develop property, be it a small renovation or a large unit development, to avoid common mistakes and do it better. I believe that the ideas we'll offer you here will help you avoid a nasty car crash and help you maximize the profits from your next development. In this video, we're going to introduce off-the-plan contracts for Victorian real estate. We're going to explore some of the basic requirements because it is reasonably important with off-the-plan contracts to be valid and binding that we get some fundamentals right. As always, the material in this video has a Victorian flavour and is correct as at August 2020, but in every case, you should get your own specific advice rather than rely on the general advice we're providing here. So let's start by exploring exactly what an off-the-plan contract is. Bear in mind that in the state of Victoria, the ownership of all land is recorded at the Titles Office by the Land Titles Office, or Land Use Victoria as they like to be known now. Put another way, that means that the map of Victoria has been cut up into pieces and the ownership of each piece of that map is recorded at the Land Titles Office. That then creates an issue where an owner wants to sell part only of a piece of land because there needs to be a process called subdivision that occurs first before the purchaser can be recorded as the owner of that part piece of land. That subdivision process obviously involves council consent, generally the bank's consent, and also registration at the Titles Office. An off-the-plan contract arises where the vendor is selling part of land and that the sale is conditional on preparation and registration of a plan of subdivision. In many cases, particularly if we're thinking about high-rise residential or other forms of development, it may also involve the construction of the residence or the premises, but this is not strictly required for an off-the-plan contract. Difficulties with off-the-plan contracts in the past have led to a number of provisions in the Sale of Land Act that are designed to protect the interests of purchasers. We'll come back to that shortly. At first glance, an off-the-plan contract may look like any other contract for the sale of land in Victoria. However, an off-the-plan contract does have to comply with a number of key requirements. The first and perhaps most obvious is that it needs to include a fairly clear plan of the land being purchased. In a perfect world, that would be a surveyor's plan, but that's not necessarily the case. The second thing that an off-the-plan contract needs to do is comply with government-mandated disclosures. These include that the deposit is negotiable, there may be an extended delay between signing the contract and settlement, and finally, that the value of the lot may therefore change before settlement. An off-the-plan contract must include what's known as a sunset provision. This is a provision that allows a purchaser to terminate the contract if the plan of subdivision is not registered within a specific time frame. The default is 18 months, but I've seen contracts that extend this sunset provision out as far as 7 years. The next point to note is that the deposit is capped at 10%, and not only is the deposit capped, but it must be held in a trust account until the contract is unconditional. That means effectively the plan of subdivision is registered and any construction is complete. This pretty much rules out the developer being able to access the deposit funds to complete the subdivision or building works. Finally, there needs to be a disclosure as to whether there's been any change to the surface level of the property. This is perhaps less relevant for an apartment style project, but is certainly more relevant where you're selling building blocks off the plan, so to speak. In 2019, the sunset clauses in Victoria were overhauled, especially in relation to residential property. Essentially, there are a number of cases where aspiring homeowners were left out in the cold. The subdivision they were relying on took longer than expected for one reason or another, and as the sunset clause was triggered, the developer took the opportunity to terminate the contract and then resell the property at a higher price, leaving the aspiring homeowner, as I said, in the cold. Naturally, the developers blamed planning delays for this and insisted that they needed some mechanism to recover their increased costs, and it wasn't simply profiteering. In any event, the government changed the rules. The sunset clauses must remain, but before a vendor/developer can rely on a sunset clause to terminate a contract, they essentially need court permission to do that. That court permission will rely on the developer being able to convince the court that they've done everything reasonably within their power to get the project completed as quickly as reasonably possible. There are a number of reasons why a vendor may want to sell off the plan. In 3 to 4 unit developments, maybe larger, it may be a requirement of the vendor's bank that they require off the plan sales before they'll fund the development. For others, it may simply be that the vendor is risk averse and locking in a sale before they start removes a large part of that risk. For others, they may simply have an offer that from the vendor's perspective is too good to miss, and they see an off-the-plan contract as a way to lock in that advantageous offer. The final point that we'll touch on in this video is the question of whether you can sell off the plan before you buy the underlying property. The short answer is yes. You can sell in an off-the-plan contract what you don't yet own. However, there need to be disclosures around this in the Section 32, i.e. the vendor statement, and there also need to be special conditions to ensure that your obligation to sell is conditional, obviously, on the settlement of your purchase. There may also be a number of stamp duty and other issues that arise, but the short point is that it remains possible. When the time comes to prepare your next off-the-plan contract, please contact Lewis O'Brien & Associates. We can tailor an off-the-plan contract to suit your particular project. This will ensure that we avoid unnecessary problems by anticipating them before they arise, that we can try to help speed up the completion of your project, and also that we can help maximize profits by identifying savings and potential recoveries. Please contact us and ask how our expertise can help improve your next project. That brings us to the end of this video. If you've enjoyed this video or learnt something from it, please share the video with a friend. Or like the video by pressing the appropriate red button, and subscribe to our YouTube channel, or you could subscribe to the newsletter available at our website, lewisobrien.com.au. Thank you for your time.